The courtroom in Washington, D.C. was tense, packed with reporters, legal observers, and quiet protesters just outside the doors. Inside, the case at hand was already a lightning rod, a constitutional dispute over whether Christian groups could be barred from praying in public parks. Cameras weren't allowed to broadcast the proceedings, but every seat was filled, and the nation was watching through headlines and live blogs. Sitting silently in the third row, not as a participant but as an observer, was Karoline Leavitt, the 27-year-old White House press secretary. Young, sharp, and respected for her calm precision, she was dressed in a simple black blazer. Around her neck, a silver cross shimmered under the fluorescence. Subtle, but clearly visible. She wasn't there to speak, she wasn't there to protest, she was there to witness. But to Judge Charles Hargrove, that was one accessory too far. Midway through opening arguments, the judge glanced up from his bench, narrowed his eyes, and pointed toward her. "Ms. Leavitt," he said, his voice echoing through the room, "this is a courtroom, not a church. Remove that cross or remove yourself." Murmurs swept across the gallery. Karoline blinked, but remained seated. "I'm not disrupting the court," she replied evenly. "I'm exercising my First Amendment right." The judge's face hardened. "You've been warned. The neutrality of this courtroom is non-negotiable." She didn't move. The silence stretched. Then came the gavel. "You are hereby fined $500 for violating the standards of religious neutrality in federal court." A collective gasp followed. Karoline calmly reached into her coat, tapped the corner of a tiny hidden camera pinned just beneath her lapel, and let it continue rolling. Her voice remained composed. "Your Honor, this courtroom allows others to wear cultural and political symbols. I will not remove a religious one simply because it makes you uncomfortable." Judge Hargrove moved on with the proceedings, but the damage was done. Karoline had just been fined, not for disrupting court, but for wearing a silver cross around her neck. And every word, every glance, every gavel strike had been recorded. Outside the courthouse, the story hadn't broken yet, but it was coming. A storm was gathering, one not built on outrage alone, but on constitutional law, undeniable footage, and one woman's refusal to bow. In the stillness of that courtroom, something had shifted. A line had been drawn. And beyond the courthouse steps, a movement was about to begin. Narrator voice, crisp and deliberate, cuts in over a black screen. One cross, one $500 0 cents fine, and the legal firestorm that shook a nation. Outside the courthouse, tension swirled like storm clouds ready to burst. Protesters lined the sidewalk holding signs that read, "Faith is not a crime," and First Amendment under fire. Journalists clustered near the steps, microphones at the ready, hoping for a glimpse of the controversy already brewing behind the stone facade. Inside, the atmosphere was no less charged. The courtroom, a sleek yet aging chamber of federal architecture, was packed to capacity. The case itself had drawn national attention. A group of Catholic parishioners were suing the D.C. Parks Department for allegedly banning public prayer circles in city-owned spaces. It was the kind of legal flashpoint that ignited both legal debate and cultural warfare. And presiding over it was the notorious Judge Charles Hargrove, a man known as much for his rigid courtroom policies as for his reputation for disliking overt religious expression. From the bench, Hargrove ruled with precision and gravity, his robe stiff, his tone colder than the marble walls around him. To him, this wasn't a constitutional debate, it was about control, about his domain, and no ornament, no argument, no cross would challenge that. Seated in the gallery was Karoline Leavitt, the 27-year-old White House press secretary. She wasn't here to make a scene, she wasn't scheduled to speak, file an amicus brief, or even issue a public statement. She came in a personal capacity, curious and concerned, but silent. Though not a practicing lawyer, she had studied constitutional law during her time at Dartmouth, and later served on the Legal Communications Advisory Team at the Executive Office. Her legal instincts were sharp if underutilized, but more than credentials, what defined Karoline was her clarity. She didn't posture, she prepared, she didn't seek conflict, but she didn't shrink from it either. And when Judge Hargrove had stopped the trial to call out her cross, she hadn't flinched. That single moment, his command, her refusal, and the fine had cast an immediate spotlight on the quietest person in the room. Now as the trial resumed, the air was thick with unresolved tension. Judge Hargrove didn't look her way, but every glance from the clerks, the attorneys, even the jurors found its way back to her silver cross. The press hadn't reported it yet, but whispers were already leaking through courthouse hallways. Karoline sat still, pen in hand, not writing, just listening, her face unreadable. But beneath the calm, her mind raced. She had never planned to challenge a sitting federal judge, let alone one with decades of institutional protection and a record of intimidating, even seasoned counsel. Yet here she was, fined in a public courtroom not for interrupting, protesting, or posturing, but for wearing a silent, personal symbol of faith. Her cross wasn't oversized. It didn't blink or glow. It was small, silver, and sat flat against her collarbone. It was no more obtrusive than the colorful bangles worn by another woman on the row ahead, or the lapel pin with a raised fist worn by a man to her left. Yet none of them were asked to remove theirs. Only her. Only the cross. Judge Hargrove, meanwhile, showed no signs of wavering. He presided over the proceedings with his usual stoicism, quoting statutes, silencing objections, and cutting off attorneys mid-sentence. But beneath his crisp rulings was a sharp disdain for anything that appeared to blur the line between religion and state, at least when that religion was Christianity. To some, he was a protector of neutrality. To others, a tyrant hiding behind judicial robes. And Karoline was quickly realizing where she stood in that divide. When recess was called, the tension finally broke into whispers and glances. Reporters began scribbling faster. The clerk's eyes darted between Karoline and the bench. An attorney leaned in to ask her something, then thought better of it. Karoline stood slowly, stepped into the hallway, and checked the footage recorded by the hidden pin camera attached to her inner lapel. The audio was crisp, the footage clean. The judge's words were clear. Remove that cross, or remove yourself. She replayed it once, twice, then tucked the device back inside her coat. She didn't smile, but her eyes had shifted. What was once irritation had turned into calculation. The legal lines had been drawn. She had tried to stay silent. She had tried to observe. But the moment Judge Hargrove made her the target of selective enforcement, he had elevated her from spectator to participant. And Karoline Leavitt didn't lose legal battles, not on First Amendment grounds, not when the record was this clean, not when the hypocrisy was this obvious. She walked back into the courtroom, took her seat, and crossed one leg over the other with calm deliberation. She didn't speak. She didn't need to. Her presence now was the argument. And it was only beginning. As the courtroom reconvened, Karoline sat motionless, her silver cross still visible, but now seemingly weighted with more than just metal. During a pause in testimony, she stood and calmly addressed the court, not as a disruption, but as a citizen asserting her rights. Your Honor, she began, her voice steady and composed, with respect, I would like to enter a formal objection to the fine issued earlier, under grounds protected by the First Amendment of the United States Constitution, namely, the freedom of religion and freedom of personal expression. A ripple of surprise passed through the room. Even the stenographer hesitated for a beat before catching up with her pen. Judge Hargrove's eyes narrowed. Ms. Leavitt, this is not a public forum. You are not a party to this case, and you do not have standing to address this court. Sit down, or you will be removed. Karoline remained standing, her tone respectful but firm. I am not speaking to interfere with the case. I am addressing the court's decision to fine me personally for wearing a symbol of my faith. That action constitutes selective enforcement and suppresses a constitutionally protected expression. Hargrove's gavel came down hard. You are out of order. Bailiff, please escort Miss Leavitt out of the courtroom. The fine stands. Gasps and murmurs filled the chamber, but the bailiff was already moving. Karoline didn't resist. She gathered her bag, nodded once to the judge, not in agreement, but in acknowledgement of the moment, and walked out under the escort of uniformed security. Her expression never faltered, but the optics were unmistakable. A young woman ejected from a courtroom for defending her faith by a judge cloaked in authority. Outside the courthouse, cameras that had been waiting for the case to break took on a new story. Reporters quickly shifted their attention to the incident. Within an hour, headlines broke across multiple outlets. White House press secretary removed from courtroom for refusing to remove cross. Disruption or defiance. Karoline Leavitt clashes with federal judge. Chaos in D.C. courtroom. Cross at center of controversy. The narratives varied wildly. Conservative outlets called it persecution. Liberal pundits questioned whether Karoline had disrespected courtroom decorum. Mainstream networks speculated whether this would ignite a religious freedom debate or fizzle into a media moment. Karoline, meanwhile, returned to her office at the White House in silence. She made no immediate public statement. But the backlash was swift. Several legal analysts took to morning shows criticizing her conduct. She should have followed court rules, one constitutional scholar claimed. Even if the judge was overreaching, she had no business interrupting the proceedings. Others suggested she was grandstanding. On social media, threads debated her motives. Some accused her of orchestrating the moment for political gain. Others posted out-of-context clips, suggesting she had disrupted the court intentionally. Even some conservative legal minds distanced themselves, warning that she may have undermined the legitimacy of future First Amendment challenges. In that moment, Karoline appeared to be losing. Her silence was painted as arrogance. Her calm was reframed as insubordination. Her constitutional appeal had been ignored, dismissed, and silenced by a system that had always known how to isolate dissent and wrap it in procedure. For the first time in her public career, she was not the composed spokeswoman shaping the story. She was the headline being shaped by others. And from the outside looking in, it seemed she was about to be swallowed by a machine far larger than her. The courtroom had removed her, the judge had ruled, the media had framed her. And the public? The public wasn't sure if she was brave or reckless. But what no one yet realized was that the moment she walked out of that courtroom, the story didn't end. It had just shifted arenas. Karoline wasn't crushed, she was calculating. And what had started as an unjust fine was about to become a national question. But for now, all anyone could see was the image of a woman in black, led out of a courtroom, cross shining under fluorescent lights, head held high, but alone. Karoline didn't retreat into silence after the courtroom doors closed behind her. She went to work. That very evening, from a quiet office lit only by her desk lamp and the glow of a single monitor, she uploaded the footage from the courtroom to her official account on X. The video, unedited and uninterrupted, showed every detail: Judge Hargrove's command to remove the cross, her composed refusal, the gavel striking, and her escorted removal. No dramatic music, no narration, just raw footage, and the truth without commentary. Alongside it, she posted a second video, filmed just hours later, in which she calmly broke down the legal precedent. Seated at her desk, in the same black blazer she wore in court, she spoke directly to the camera. In 1993, the United States Supreme Court ruled in Church of Lukumi Babalu IV City of Hialeah that government officials cannot selectively restrict religious expression under the guise of neutrality. The court reaffirmed that symbols of faith, whether worn or spoken, are protected under the First Amendment unless they disrupt public order. Wearing a cross quietly in a courtroom does not constitute disruption. It constitutes identity. She paused only to lift the very cross from around her neck and place it gently on the table before her. What happened today was not about neutrality, she continued. It was about selective enforcement and selective intolerance. She then showed still images from the same courtroom session. A woman in the front row wearing a shirt with a bold political slogan across her chest. A man nearby wearing a necklace with a large golden Chinese character for luck. Neither of them were asked to remove their symbols. Neither were fined. "So I ask," Karoline said, her voice steady but sharpened by logic, "why was the cross the only symbol deemed inappropriate? And who decides what beliefs are allowed in an American courtroom?" She closed the video with a simple line, not spoken with outrage, but with purpose. "This isn't about me, it's about what comes next, when faith is policed by fear." Within hours, both videos had been viewed more than 2 million times. Within 12 hours, the numbers had doubled. Dozens of attorneys, including respected First Amendment scholars, reposted her legal analysis. Civil rights organizations issued public statements. Even journalists who had initially cast her as a disruptor began to rethink their headlines. The footage couldn't be spun. Her voice couldn't be ignored. What had seemed like a courtroom overreach was fast becoming a national debate. News outlets scrambled to get her on air. Legal commentators began quoting Lukumi Babalu IA on primetime television. Constitutional law professors emailed their students new case studies. Watch Karoline Leavitt's response to Judge Hargrove. Be ready to discuss selective neutrality. Across dinner tables, classrooms, and boardrooms, the conversation shifted from, "Did she go too far?" to "How was this allowed to happen?" And beneath it all, pulsed the most haunting question of her message. Why only the cross? Karoline didn't gloat. She didn't lash out. She simply let the facts do what Judge Hargrove had refused to speak. And, for the first time since that gavel fell, she wasn't alone. The nation was listening. The spark Karoline lit didn't just catch fire, it became an inferno. Within days of her video going viral, national newsrooms shifted their focus. What began as a legal footnote, one woman fined for a cross, was now the center of a much larger storm. Investigative reporters began digging into Judge Charles Hargrove's prior rulings, combing through years of transcripts and courtroom behavior. Patterns emerged, chilling in their consistency. In case after case, religious symbols, specifically Christian ones, had been quietly discouraged or punished under his courtroom policies. Several rulings revealed that Hargrove had previously reprimanded individuals for reciting brief prayers before testifying or referencing God in courtroom statements, but the revelations didn't stop there. Former plaintiffs, defense attorneys, and courtroom visitors began coming forward, emboldened by Karoline's stance. A Muslim woman who had attended court for a civil case recalled being told by the same judge that her hijab was visually disruptive and was asked to remove it or sit in the hallway. A Jewish teenager, fined for refusing to remove his yarmulke while serving as a witness, now stepped forward, his parents speaking with media for the first time. The testimonies poured in. The image of Hargrove as a hard-nosed, by-the-book judge was unraveling, revealing something more troubling beneath the surface. An ideology cloaked in judicial authority. Legal organizations began issuing open letters. The American Civil Liberties Union, the Beckett Fund for Religious Liberty, and the First Liberty Institute, groups often on opposite ends of the spectrum, came together, not just to defend Karoline's rights, but to demand a federal investigation into Judge Hargrove's conduct. Within a week, a formal inquiry was opened by the Judicial Council of the D.C. Circuit. The Department of Justice issued a statement noting it was reviewing the consistency of courtroom neutrality standards with constitutional protections for religious expression. And then came the defining moment. Karoline was summoned to testify before the Senate Subcommittee on the Constitution. The room was packed. Senators, reporters, and observers lining every bench as she sat alone at the witness table, the same silver cross around her neck. Her testimony was precise, compelling, and deeply grounded in law, not emotion. "Your Honorables," she began, "this is not about politics, and it is not about performance. It is about principle. If a courtroom enforces neutrality by silencing symbols of faith, but allows symbols of ideology, it is no longer neutral. It is choosing a side, and that choice, when backed by the force of government, becomes suppression." She went on to cite not only Church of Lukumi Babalohai v. Des Moines, Masterpiece Cake Shop v. Colorado Civil Rights Commission, and West Virginia v. Barnett. She backed each point with page numbers, precedents, and constitutional interpretation. And then, with clarity and resolve, she proposed a policy change, mandatory First Amendment training for federal judges, a revised code of courtroom conduct that protects silent, non-disruptive religious symbols, and an independent task force to review judicial behavior complaints involving faith bias. Her words didn't shout, but they struck with more force than any protest chant. When she finished, the room was silent. Then, a single senator, one who had previously questioned her political motives, leaned forward and simply said, "Ms. Leavitt, you didn't just come here with a complaint, you came with a solution." The applause that followed was quiet, respectful, but in the digital world, the reaction was seismic. Headlines read, "Leavitt's testimony shapes judiciary," "The cross that changed the conversation," "One witness, one symbol, one constitutional reckoning." And for the millions watching at home, it was more than a legal argument. It was a cultural awakening. Parents began asking questions at school board meetings about faith representation. College students held open forums about bias in public institutions. Faith leaders across the country cited Karoline's case in sermons and bulletins. What Karoline had ignited wasn't a culture war, It was a legal movement, with documents, dates, and declarations. And it was working. The Judicial Council announced it was placing Judge Hargrove under temporary suspension, pending a full ethics review. Several of his recent rulings were being reevaluated. New legislative drafts were already circulating through the Senate, proposing a clear and binding set of religious expression protections inside federal courtrooms. But perhaps the most powerful moment came not from a courtroom or a Capitol hearing, but from the public itself. A school principal in North Carolina reinstated student-led prayer circles that had been banned for years. A Texas judge issued a statement reinforcing his court's openness to respectful personal expressions of faith. And a high school civics teacher in Ohio redesigned her curriculum to include Karoline's testimony as required reading for her students. Across the country, people weren't just agreeing, they were acting. And in living rooms and courtrooms alike, the realization settled in. Karoline Leavitt hadn't just made a point, she had made a change. She didn't just win the argument, she rewrote the rules. The ripple effects of Karoline Leavitt's testimony did not stop at headlines. They shook the foundations of the judiciary itself. Within a week of her appearance before the Senate subcommittee, Judge Charles Hargrove was placed on official administrative leave pending a full investigation. The Judicial Council cited substantive concerns regarding impartiality, consistency in courtroom standards, and adherence to constitutional protections of religious liberty. It wasn't just the incident with Karoline. Her defiance had cracked open a long-ignored pattern. Legal analysts began re-examining a series of past rulings under Hargrove's gavel, cases where rulings had raised quiet eyebrows but never formal complaints. A closer review uncovered troubling consistencies. Individuals penalized for wearing rosaries, families reprimanded for mentioning prayer in victim statements, even a pastor fined for placing a small Bible on a witness stand. These weren't isolated oversights. They were threads in a broader pattern of selective enforcement. Several of Hargrove's judgments, particularly those related to religious organizations or individuals, were now flagged for review. Appellate courts reopened filings, while civil rights groups prepared amicus briefs demanding reversals in cases potentially tainted by religious bias. What once passed as stern judicial discretion now looked suspiciously like ideological suppression, and the courts, for the first time in years, had no choice but to respond. In an emergency session, the Senate Judiciary Committee issued a bipartisan recommendation, a formal code revision that would clearly state that silent, personal religious symbols such as crosses, hijabs, yarmulkes, or other non-disruptive expressions cannot be restricted in federal courtrooms under the guise of neutrality. Neutrality, the committee clarified, does not mean erasing identity. It means ensuring all identities are protected equally. The Department of Justice, recognizing the scale of institutional failure, issued a directive mandating mandatory First Amendment training for all active federal judges. The program would be developed by a coalition of constitutional scholars, legal ethicists, and civil rights attorneys, many of whom had already praised Karoline's testimony as textbook-level clarity. For the first time, the phrase religious freedom wasn't being used as a partisan slogan, but as a constitutional standard that both liberals and conservatives agreed had been unevenly applied for too long. In the days following, federal courthouses across the country began adjusting their public-facing policies. Signs that once vaguely referred to appropriate decorum were now updated to state explicitly, personal religious attire and symbols are welcome provided they do not disrupt proceedings. This wasn't just symbolic, it was binding. Karoline Leavitt's stance had become codified policy. The media, once divided in its portrayal of her, now aligned in admiration. Editorial boards ran opinion pieces titled "She Knew the Law Better Than the Judge" and "The Woman Who Made the System Remember the Constitution." Networks that had initially labeled her courtroom moment a stunt began acknowledging it as a landmark act of civic courage. One broadcast journalist on a major evening news program declared, "This is not just a viral moment, this is jurisprudential legacy in the making." The praise extended beyond headlines. Law schools invited Karoline to guest lecture on constitutional advocacy. Civil rights groups asked her to join advisory panels. Senators who had never once agreed on judicial reform co-sponsored a bill informally referred to on the Hill as Leavitt's Law. In legal circles, the term Hargrove Standard quickly evolved into a cautionary tale of what judicial overreach looks like when unchecked, and what happens when it is finally confronted by clarity, courage, and constitution. For Karoline, the personal vindication was quiet. She didn't hold a press conference or embark on a media tour. She let the institutions speak for themselves. And speak they did. When the Department of Justice held its first judiciary training session under the new mandate, her courtroom footage was included in the opening module, alongside commentary not from pundits, but from professors at Yale, Stanford, and Georgetown. What began as a $500 0-cent fine for wearing a silver cross had now turned into a recalibration of how the American legal system balances power and principle. Yet for all the systemic change, perhaps the most profound shift happened in public perception. Americans began to ask better questions about the limits of authority, the meaning of freedom, and the quiet ways bias can be enforced without anyone raising their voice. In classrooms, churches, courtrooms, and across social media, the conversation shifted, not from outrage, but toward education, toward clarity. Karoline's name no longer appeared beneath the words controversial moment. It appeared beside phrases like model of constitutional integrity and the 27-year-old who reminded the courts what the First Amendment really means. She hadn't gone looking for confrontation. She hadn't asked to become a symbol. But by standing for something most people take for granted and backing it with law, logic, and unshakable resolve, she had done more than win. She had changed the system from the inside out. The morning sun glinted off the white marble steps of the Capitol as Karoline Leavitt emerged from the final congressional hearing. She didn't wave. She didn't pause for the cameras now lining the plaza. She simply walked, measured, composed, with the same quiet strength that had carried her from the gallery seat of a courtroom to the center of national reform. A light breeze caught the hem of her black blazer, and the silver cross around her neck caught the sun, casting a subtle flare that momentarily outshone the flashbulbs. Reporters called her name, but she didn't turn. Her job wasn't to perform. It was to protect what should never have been questioned in the first place. As she reached the bottom of the steps, a small hand tugged gently at her sleeve. She turned, and standing there was a little girl no older than 10, wearing a denim jacket too big for her shoulders, her backpack half open, a crumpled piece of construction paper in hand. She didn't say anything at first, just looked up with wide eyes full of something far heavier than her years. Then she handed the paper to Karoline. It was a simple drawing, a stick figure woman with brown hair, standing tall beside a large silver cross. Above it, in crooked handwriting, were the words, "Thank you for standing up for girls like me." Karoline knelt down, took the card with both hands, and smiled. Not for the cameras, but for the little girl who, like so many, had just seen for the first time what courage and silence could look like. No speeches followed. No security rushed her away. For a moment, the world seemed to pause, watching the quiet exchange between generations. Then Karoline stood, gave the child's shoulder a gentle squeeze, and walked forward, squeezing his shoulder, and gave the child's shoulder a gentle squeeze and walked forward. The crowd parted. The cameras followed, but she never looked back. She didn't have to. Her work had already echoed through chambers of power and courtrooms of doubt. The screen fades as she walks into the distance, the silhouette of her cross glinting softly in the light. The final frame lingers, not on her face, but on the back of her figure, walking alone yet surrounded by the shift she had caused. And then the words appear, white on black, steady and still. She didn't fight for attention, she stood for conviction, and the country stood with her. Fade to black, no music, just silence, the kind that comes not from absence, but from reverence.